Okay, I think we're ready to go. Good evening, everybody. Lori Harold, President of the Eastern Bar Association. Tonight we have Ira Friedman, who is a family law attorney, and Judge Susan Lopez-Giss, who I've known for many years. She was in the East District for 7 years and came to many of our bar functions over those 7 years. They're going to do a presentation tonight on execution of judgments, and I'm going to let them do a brief little biography, and then they have a PowerPoint. It should be up on your screen for you to watch. So with that, Mr. Friedman and Judge Giss, I'll let you go ahead.
All right, Ira, do you want to start?
Sure, hold on. Thank you. I am a certified family law specialist, and I've just started my 50th year in practice. In the past, I did do some appellate work, and I am the prevailing attorney in the marriage of Gavron and the marriage of Keach, which, if you're a family law attorney, you probably heard of both of them. My practice is traditional family law, but we end up getting referred cases by other family lawyers who the call goes something like this. I just got a great result for my client, but the other party is not paying. Take it over. I said, well, you can figure this out. There's no magic. It's all in the Code of Civil Procedure. They say, I don't want to learn. So that's probably how I got to this thing. And it's sort of a niche practice along with our traditional practice of family law. And I have done also consulting where my name appears nowhere in any of the pleadings. So that's sort of a background. And it started actually, I got into this part of it because before I was a lawyer, I worked for General Motors for 7 years, and I was the credit manager for Frigidaire, which they owned. And some of this stuff I knew even before I went to law school. And so that's how it started for me.
All right, I'm Susan Lopez-Giss, and I have no idea who is on the Zoom lesson or MCLE that I may know other than I know Lori. And I was a LA Superior Court judge for 15 years, and the first 7 years was in Pomona. I sat in Department B, and for those of you who remember or old enough to remember, I was sitting with Commissioners Christian, let him rest in peace, and Commissioner Crabb. And after that, I went to Chatsworth, and then my last 3 years on the bench, I was in Santa Monica doing settlements. And I predominantly did settlements, and now I am retired with ADR, and I'm pretty much a settlement judge. I do actual private judging, but those of you who know me know that I believe in settling cases. But before I was a judge, I was general counsel for the Department of Water and Power. And before I became general counsel, I was attorney responsible for representing the commercial division. Many people do not know, but DWP means to many people deep, wide pockets. And they felt that there was no obligation to actually pay not only their bills for power and water, but also to follow through with money that they may have owed on contracts. And it was one of my responsibilities to collect. And so the supreme power of collection when you're with DWP is turn the power off, and you would have no idea how fast the bills get paid. But short of being able to turn the water and the power off, and we typically did not like to turn the water off, unless you are working in the field of the Sopranos and you have other methods of enforcement. The main method of enforcing in this state is the Code of Civil Procedure and the rules and procedures that are established by the Code of Civil Procedure to collect judgments. And I understand that many people have judgments, and that's why we enforce we entitled this presentation, "You've got the order, now how do you get paid?" And Ira and I were friends, and Ira said to me, maybe it would be good to make these presentations to explain to lawyers how to get paid. There's simple procedures to do it, but I always end, but I'll start this time. If you really don't want to do it, just hire Ira. So Ira, do you want to start?
Well, one thing you didn't mention is what you had to do with domestic violence laws. Even though it's not part of this presentation, because that's another aspect that people don't realize, working for the city attorney, which is DWP is part of.
Yes, all right. Just briefly about my resume. I was a criminal prosecutor in the city attorney's office for the first 15 years of the 30 years I worked in the city attorney's office. And under Bert Pines, I had the opportunity, because of my refusal to dismiss cases, I wrote the domestic violence guidelines, which became the prototype for the country back in 1977. I wrote the restraining order law, not the restraining order law as it is today, but the initial restraining order law for domestic violence cases. And not only that development of prosecution program for domestic violence, but it was also child abuse, and then went to sexual abuse and sexual assault and harassment. I did that for 15 years until my late husband, who was a retired police officer, said, "You're looking at all of our friends and the children's soccer coaches with weird looks. You need to get out of this because you're too close." And so that's when I transferred to DWP. And I will say this, part of the reason I asked to do family law, those of you who may remember Judge Bob Schneider, who was the presiding judge of, or supervising judge of family law, he was ready to assign me to a criminal DUI court. And I said, no, I want to do family law because I don't like what people do to their children when they go through divorces. And with that, I was assigned to the East District, and a very, very lucky assignment for me. And it all began there.
Okay,
Ira.
so the judge just mentioned about everything is in the code. It's in Code of Civil Procedure, section 688 through 724.250. You may want to go to slide 2. There we go. So one of the things about you have to do is to start with the language of the order. It's very important to have a specific due date. Don't just say it's due so many days from the date of the order, because one, does that mean the date the order was pronounced, or is it the date the judge signed the order? Just put a specific date in there. Also, if it's an installment order, which I've seen, you need to have an acceleration clause. If not, it doesn't matter what the total amount of the order is. It's going to take forever to get paid because there's no provision in there, such as if one payment is so many days late, the entire balance becomes due and owing, and interest will start to accrue from the date of default. That's sort of a sample. And sometimes you have to speak up when the judge is making an order. Sometimes it's usually with attorney's fees, and because some judges, for whatever reason, it doesn't cross their mind or whatever. So I would say, Your Honor, are you going to include an acceleration clause? And then they will or not, but at least you brought it up. So I think it's very important to insist. Why don't we go to slide 3? Okay. The two types of abstracts. One is for support, whether it's child or spousal or family, and the other is for anything else, attorney's fees, property division, or whatever. And you can actually record in every single county in California if you want. But if you don't think they're going to own any property in Trinity County, I think you may be wasting your time and effort. But you can do it in all 56, I think it's 56 counties. It acts as a real property lien in the county where it's recorded. And the important thing is that if you look at the form, which are judicial council forms, you will see that there's little boxes there and they say, there are two different things. One of them asks for last four digits of the social security number, and the other one, they ask for date of birth and driver's license. And it's so easy to say unknown, unknown, but if you are representing someone in a dissolution of marriage, the odds are you're gonna have a tax return. And you say, well, what difference does it make? There's a Court of Appeals case called Keel versus Reich, R-E-I-C-H. It's a 1985 Court of Appeal decision at 169 Calap 3rd, 112. And it says that if you had access to the information that's on the form, and you didn't insert it, your abstract may be void. The other thing is something called equitable subrogation. Equitable subrogation is something that sounds like it's from not Star Wars, something out of space, and it goes like this. If you're the first lender, if the first lender has a lien for a home, and a second lender comes by and refinances for the same amount, you're saying, well, I have an abstract, I should get paid. This equitable subrogation, and there's case authority, says no. The second lender steps into the shoes of the first lender, which had recorded ahead of you, and you don't get paid. And it gets even more complicated. If the first lender, even if you've recorded, but before the person bought a house and the first lender has a purchase money loan, that has priority by law. And sometimes you find out these things the hard way, which we recently did on one of these. So be careful when you do this and fill out the information that's required. Why don't we go, Judge, to the next slide?
Slide
4.
writ of execution. Okay. So I think you'll understand this far into it, that this is not the types of code sections you read when you want to stay awake. This is dry and specific point oriented. And the reason I say it at this point in time is because many times people will get orders to pay specific amounts of money, selling property, selling the business, selling or liquidating funds from accounts. And if you don't record your judgment, if you don't record what you have been successful in getting an order or a judgment for, it becomes a useless piece of paper. One of the common ways of getting paid is a writ of execution.
This slide is wrong.
Okay.
It repeatedly.
Okay, so if you look at number 4, you need to record this execution with the county, and it acts like a lien on the real property.
That's what I'm saying. This is wrong.
It's wrong.
Yeah, just go to this information on there.
The writ of
Slide 4 is wrong.
And we didn't catch it.
We didn't catch it. It's actually, I think, duplicated of 3. Yeah,
Okay.
it's same as 3.
Okay, but I'll just say it. I'm sorry.
All right.
The writ of execution is governed by Code of Civil Procedure, section 699.510. This is the document that is required for the sheriff or process server to serve a levy or an earnings withholding order, which is what you want in the support issues, in support situations. This is very county specific. Each county has their own form. In Los Angeles, it's form FAM 027, and it's an application for a writ of possession, sale, or execution. If you don't have the proper form, the clerk may not accept it and the sheriff may not accept it. So you need to make sure that you have the right form, and every county if you go on the State Judicial Council website, you will get the form, but then you have to look for the county-specific form on your county website. This application for writ must be signed by your client, except for attorney's fees, in which case the attorney can sign the application for writ of execution. The same is true for the sheriff's instructions from one county to be used in another. You also need an MC 012 memorandum of cost document after the judgment in order to get a writ of execution issued in LA County and some other counties. Next slide. Next slide. All right, this is correct. The judgment debtor exam. This can be good or bad. I don't know how many people who are listening to this have ever conducted a judgment debtor exam, but in a dissolution of marriage, there is a lot of information that you may have before you enter in this exam from the INE, the declarations of disclosures, the tax returns, which are good for Social Security numbers, and bank records. When you want to find out about bank records, oftentimes people will say when they come in there, they don't know or they've closed the accounts. But the earlier documents that were filed when they originally filed the dissolution or filed the response, much information is obtained there. And when you have that information, you can then proceed to go with a debtor exam. Oftentimes they'll say that the person who's conducting the exam will say they didn't get much information. But if you walk in with the information, at least with respect to the background financial information, you oftentimes will get information that the examinee did not realize that you knew so much, and then they talk. A third-party examination can be effective if the third party is holding the property of the debtor. For instance, a person who, the bank, who may have the loan on the property. This application for debtor exam, an ORAP, must be personally served. There's no substitution of service allowed. And if you have a subpoena duces tecum, and you don't have one, the ORAP is worthless. You also need to have a declaration of support in order to request the third party's presence. And bank searches are very difficult. Ira says that sometimes he just serves all four major banks: Chase, Wells Fargo, Bank of America, and Citibank. Westlaw can have some public records, but many people will actually hire private investigators to do these types of checks. But a lot of this information is online. The next slide.
Okay. All right. There's the next slide, but I'm going to go off script, as some politicians say. There's another thing we did not include, and it's something called a lien on a cause of action. There's a form, a Judicial Council form, AT, Apple Tom 180, and it's to be used where you can file a lien in a lawsuit where the debtor in your action is a plaintiff or a cross complainant, and that prevents the defendant from paying the plaintiff in that civil suit without satisfying the judgment. The form is pretty self-explanatory about what information you need, but we have used it where we may have a civil judgment and we file in the dissolution of marriage action before the property has been divided. So it's another tool in your tool chest as far as enforcing the judgment.
Could you give the form number so people who
I did.
Okay. You want to say it again?
AT Apple Tom 180. It's a Judicial Council form. So now can we go to the next slide? Okay. As the judge just mentioned, one of the things we recently tried when we didn't know where the bank was, we sent the process server to those four major banks. One of the things that we've done sometimes the sheriff has two speeds, slow and slower. So what we've done is we've hired a private process server to serve the banks, and the private process server has to go, and this is a word of art, which I'm not sure I understand, opening a file with the sheriff, and then they can serve it. And the reason for doing that is if you know the specific date or time, there's gonna be money in the account. With the sheriff, depending on where you're having it served in in a county, you probably are gonna wait a long time because the sheriff has limited resources for serving it. And the other thing, which kind of dovetails to this as far as getting a writ, you may want to get a writ for both, let's say, Los Angeles County, and you may want to also get a writ at the same time for Sacramento County. And you say, why would I want a writ for Sacramento County when I'm down here? The reason is there's a number of banks, the agent for service of process is in Sacramento County, and it's an institutional company called Corporation Incorporating Services or something like that in Sacramento. And you'll have to have the sheriff up there serve the agent for service of process with the writ of execution. So that's one of the things to think about. The other thing is, as far as financial institutions, stockbrokers, this varies stockbroker to stockbroker. Sometimes the account that the debtor has both cash, which is pretty easy to deal with, but it may have securities, both equities and bonds. And the broker does not want to get involved in deciding which ones to sell because it could cause some tax consequences for their customer. So some of them will not sell it without a specific order of sale, which means you'll have to go back to court to get that. And what I usually do, whether it's asking for a order of sale or in the instructions to the sheriff, I say, sell these securities in alphabetical order. And that way you don't have to worry about what's in the account and so on. And it's the same as if I have to go to court and get a specific order to sell the securities. I put in there, sell in alphabetical order. And also, one of the things that people are not aware of, and this is only for support, is IRA accounts. You can levy on IRA accounts for support. You could also levy on pensions for support and 401ks. And it's going to depend on what kind of a pension, what kind of an account it is, whether it's a defined benefit or a defined contribution. If it's a defined benefit, unless the party ends up in a situation where they're old enough to start getting the monthly benefits, you're not going to be able to get anything. And you can't force them to start receiving their benefits. But if it's a defined contribution, which is the easiest way to explain it is, there's a pot of money sitting there. So you have to find out specifically what the employer offers. I'll give you an example. The Screen Actors Guild only has a defined benefit plan, but the motion picture industry, for the people behind the camera, they have both a defined benefit and a defined contribution. So if somebody owes, as an example, backs, and you can only go in for support. If somebody owes a big amount of support, you can get all of it out of this pot of money that's sitting there, assuming they have that much in it. So that's something to think about. As far as vehicle.
I want to interrupt you for a
Okay.
minute. You know about this because it's listed in their disclosure statements. What if they didn't issue it, didn't disclose? You know that they've worked in the industry, so you would make an inquiry?
Yeah, I mean, the other thing you can find out, sometimes the pension has been divided with a quadro between the spouses, so you know from the judgment where it is. In other cases, you have to noodle around. I had somebody ask me about the father, it was a paternity case, the father played professional sports, and I asked a little around, and got some information off the internet and found out that they had both a defined contribution and a defined benefit. The person is too young, he's only 43, and this particular league requires to be 45 years old, but he has that pot of money there, and the woman has not been paid child support for some time, so that's something to consider. Cars, the problem with a car is that there has to be $1,800 of equity before you can do anything. And if it's a leased car, you can't do anything because the debtor doesn't own the car. It's owned by the leasing company. And unless there's enough equity in the car, you're spinning your wheels in
Why do you
doing
have,
it.
why do you have private process server up there?
That's for the writ of execution. The vehicle has to be sold by the sheriff. And, every once in a while you'll find somebody, let's say is a car collector, and they have cars and there's no liens on them. But the key there is you're gonna have to go to court and get what's called a private place order. Because if you don't have that, if the sheriff comes to the house and says, "Will you open the garage?" and the debtor says, "Nah, I don't think so," the sheriff has to leave. If you get a private place order, and depending on the court, some courts you can get it ex parte without notice, others make you give notice, which defeats the purpose. If the sheriff goes there with the private place order and says, "We open the garage," and the debtor says, "Nah, I don't think so," the sheriff will say, "Well, here are your options. You either open the garage or we knock it down, your choice." So that's something to consider. You can also sell real property. Here's the difference in types of property. If it's a home, you're gonna have to have a drive-by appraisal, and you're gonna have to have a litigation guarantee. And the equity, the homeowner's exemption, which used to be somewhat modest, is now the average selling price of a house in the county where the house is located. And that is about 675,000 is a good estimate. It varies by county. And it's very difficult to sell somebody's dwelling. The other kind of property, if it's commercial or industrial, all you gotta do is send a check to the sheriff, say, sell, and that's it. There's nothing else to do, and there's no exemption to it. So that's kind of a rundown on what the options are in that case. To sell the house is, you're gonna run into about $2,000 to $3,000 out-of-pocket expenses. That includes the sheriff's deposit, which is about $2,000, a drive-by appraisal, which we have a real estate broker that does it and does the declaration for, I don't know, $200 to $300 or so, and then a litigation guarantee with a title company. So that those three comprise around the $2,000 to $3,000.
But isn't there an exemption that applies?
Yeah, the homeowner's exemption for a house is about $650 or so.
So when you're talking about all these levies, it can be incredibly expensive to go and get this. So isn't it practically something that isn't done unless there's enough equity or enough in all of these accounts to make it worthwhile?
For a house, you can, if you have any relationship with a title company, you can get a property profile. The property profile will kind of give you a ballpark of what the house is worth. It will also give you a copy of the first trust deed, which will show how much the original loan was. Obviously, it's gonna probably be less. You don't know how much it is, but that'll give you a kind of a guide to see if it's even worthwhile to do. And it's becoming harder and harder. The exemption used to be anywhere from 50,000 to 150, depending on who was living in the house and their age. And now it's this around 650. I think they're trying to emulate Texas and Florida, which have no limit on the exemption for a homeowner. So it's becoming more difficult to sell a house, but commercial property is a lot easier. Can we go to the next slide? Wage garnishment. there is a federal form to serve on the employer, even out of state. Also, you can send the earnings withholding order to the sheriff. You don't have the earnings withholding order. You fill out the form, an application for earnings withholding order, which is I think it's a judicial council form, WG1 or something. And the sheriff actually issues the order. And the thing that's important with that is that for some reason, even though you put it on there, there's another form where you have to have the social security number, which, by the way, you also have to do that with bank accounts. A lot of people think you need it when you levy on a bank account, you need to know the account number. The banks keep track of everything by social security number. Also, you can get 25% for non-support of the person's debt and 50% if it's for support. Also, a lot of people don't realize you can garnish Social Security, and you can also besides Social Security, you can go after other types of pension benefits, which I spoke about, and see if there's more on this subject. And if you're going to go after money in a pension plan, you don't have to use this procedure for wage garnishment. You can get a form, which a lot of people have never even seen. It's a judicial council form. It's called a request for quadro for support. It's not a quadro where you have to hire another lawyer. It's form FL 460. And it's fairly easy to fill out. Some courts require a hearing if you're asking for arrearages. Some courts don't. I've had it both ways where the court rejected it and said you're gonna have to set a hearing because you're asking for a certain amount of arrearage. Others just have signed it the way it was submitted. So that's another way you can go after the money that's owed from a pension plan. And it's fairly easy form to fill out. And I think we're ready to go to the next slide.
Next slide, yes. All right. These are the kinds of orders, charging and assignment orders, that can actually force people to pay. And what this actually means is that you are going to go to a partnership, you're going to go to an LLC, to an entity that has a lien or has money that it holds for the person who owes the money, such as there is a distribution going to be given from a partnership, or there is residuals or royalties or rent due. With this charging order or assignment of interest, your client will then get paid before the person is going to get their royalty or their partnership distribution. For example, you have a partner in a law firm who was ordered to pay X amount of funds either for the house or support or equalization. You file this document in accordance with CCP section 708.310 and 708.520. And by filing this order that is signed by the court, you then go and become the recipient of the distribution or the royalty. It is something that law firms don't like to get involved in, and usually they'll lean on their partners, or the companies that have to pay the royalties don't want to be involved with it. And it actually is a very, very strong incentive to get the person to pay up. It charges interest on the LLC or partnership with the debt, and it's akin to a lien. You could also follow it up with a request to sell the interest. So if you're a partner and you're not paying, this order could actually force that an individual to sell their interest in the partnership in order to pay. You have to serve all of the parties for the charging order. For the assignment order, you only have to serve the debtor. And I think in understanding this provision in the law, which many people don't even know exists, it's a very effective way of getting people who think their money is not under their control, and I don't get the I don't get the residuals, I don't get the disbursement. They may not get it, but if they're entitled to it, once it does vest, your client will get paid. Next slide.
Before we go on, I want to dig a little deeper into this royalties and residuals. And the reason is some of these terms some of them are antiquated terms, some of them are words of art in the various industries. As an example, if you have somebody that recorded music and holds some portion of the copyright, and the reason I say some portion of the copyright, there's two parts. There's the copyright of the publisher, and there's the copyright of the person who composed it. And there's three different entities that keep track of that and pay out the money. There's ASCAP, there's BMI, and then there's another one. And then there's a fourth one that pays out royalties. It's called Sound Exchange, for people who are like engineers, but their contracts provide for royalties. The interesting thing about royalties in music is it goes on for almost ever. And there's actually no way to tell, because what happens is if a band goes on the road and tours, they're going to make some money on the tours, but also their royalties tend to go up also when they're on tour. And you will also we've gotten a check for 1 penny, because that's all was done, and a lot of times the client thinks, well, now that you got this assignment order of the royalties, the money will just keep flowing in. It'll come every 3 months, the money. In fact, you can arrange to have it wired to wherever rather than getting it by check. And the same holds true with movies. It's going to depend on whether they're above the line or below the line as far as what their contract provides. So there's a couple sources. A lot of people will serve a writ of execution on Screen Actors Guild. Screen Actors Guild does not pay anybody any money. It keeps track of the money. So it's a two-step process. You may have to subpoena the records in a third-party exam from Screen Actors Guild, and Screen Actors Guild will give you this big, long printout, and the printout will show you where the money is coming from. It may say that it's coming from a studio. It also may come from a company called Entertainment Partners, which is a payroll company, which is technically the employer sometimes in a movie. So even though the movie is made by a major studio, the actual employer is Entertainment Partners, which obviously gets the money from whoever's financing the thing. So that can be a great source. And the same with book royalties, although there's not a lot of authors who earn a lot in royalties, it's not as much, but movies and TV, and the thing, there's a separate source, but it's harder to look to. We've never been able to do it, is when somebody goes on tour, because by the time you figure out where they are, they've already left and they've already gotten the money. So that usually doesn't work. And also, you can also get from the label itself, for if there's money being paid from the label to the recording star or entertainer, whatever you want to call it, because there's terms called mechanical and non-mechanical royalties. I'm telling you, I went to a seminar and I did a shot of the slide that was presented of all the different kinds of royalties there are in the music world, and it's very complex. Some of the terms are very old-fashioned. Okay, so now let's go to
Before we do that, I just want to underscore the level of intricacy getting money can result in. I can tell you from my previous experiences as the commercial attorney for DWP, as many ways as this presentation is showing or illustrating how you can use different code sections to go get money, there are 10 more ways being developed right now of how to avoid and not pay. And many of us, especially as a judge, make orders that people are going to be required to pay, getting off the bench, shaking our heads, thinking the other side's never going to see the money. It's just going to be impossible to see the money. And that people develop or create entities to receive the money, and it is so distant that tracing it and finding it is an art form. And so I say this because at the time you're in the litigation or in the dissolution action, and you know where the money is, and there are specific accounts that are listed, it might be wise at the time of the judgment to require an order to keep the other party, if there's a payment obligation, of providing updated statements as to where the money is or where it is been transferred to, upon order of making sure that the court retains jurisdiction over this. With somebody having that kind of hook hanging over them, they don't think about it at the time, but it is something that they're obligated to do. And I think, why should you do the tracing if there's an order that they have to keep providing it? It is certainly better than post-judgment interrogatories, which the Code of Civil Procedure provides. But I'm just offering that as a thought and a practice tip when you're preparing your judgments or your orders. Okay, next slide.
20 minutes to go.
Okay, till-tap leaving. So this is where you have a keeper who goes in and basically utilizing the sheriff to have somebody there taking the money in when in a like a shop, like a florist shop, and you're there collecting the money every day. The practice tip is that everything is timing. If you have this levy done, or have the keeper coming in January 12th, there's not a whole lot of business for florists most of the time, January 12th. But if you have the keeper going in February 13th or 14th, Valentine's Day, you're more likely to be successful. So this is a timing and strategic tool to be used, I think, strategically. And I don't know if people necessarily think about that, but there are times in ebbs and flows in every business where you pretty much know when the money's going to come in. And so just keep that in mind. Next slide.
One of the things I was going to mention as far as the till-tap, depending on what branch of the sheriff's department, what location, sometimes it takes forever to get them to have enough personnel to go into the business. So it's kind of hit and miss. And they're it's the old story. It's a crooked card game. It's the only card game in town. So you're at their mercy. Next, we're going to talk about receivers. You need a specific business to be appointed over, and it can also be appointed to sell real estate or an asset. And sometimes, because of the amount of paperwork, it may be easier to hire a receiver or have the court appoint a receiver to sell the real estate, where in some cases you can just do it through the court and get an order that the clerk can execute certain specific documents. Here's the thing that you got to remember, that if the debtor owns a corporation, you have to, and you ask that in the order that the debtor turn over the stock to the receiver. My guess is the debtor is going to say, I don't know where the stock is. I have no idea. So you may want to include in the proposed order that in the event the debtor does not turn over the stock to the receiver, the receiver is authorized to issue new stock in the corporation in the name of the receiver. That way the receiver gets control of the corporation. The important thing about a receiver, which I always call the death penalty of enforcement tools, because it's extremely expensive, and you're having a third party picking the pocket of the debtor to get money from them. And what comes up is a lot of times when people are opposing the receiver, they'll want to increase the amount of the bond that the receiver has to get. And as one receiver said in court, I don't care how much you increase it, you're going to pay for it out of the till anyway. So you're just working against your own interest. What is important is to find a receiver that you can work with before the motion is filed. And the reason is the whole thing boils down to the proposed orders you're seeking, because the points and authorities are going to be pretty much the same. There's not much really to say about it, other than usually the code will say you have to try other enforcement tools because it's so draconian. That having been said, a good potential receiver, if you tell them, you know, I have a widget business, and they'll usually go to their file and say, you know, I had one like this. Here's some specific orders that apply in this kind of a business, and that will help you as far as putting the motion together. And when you put the motion together, you're going to say what you're looking for is see attached proposed order. And sometimes the orders run very long. And remember, once the receiver appointed, it's not your receiver, it's the court's receiver. And as such, since it's the court's receiver, the receiver has the ability to get orders you may not be able to get as easy or as fast, because if there's some problems of non-compliance, it's sort of a slap in the face of the court, so to speak, and the receiver may be able to go in ex parte and get orders that you, as one of the party's attorneys, would have to file a notice motion to get. So it's good to be able to have that. It's not used that often, but it's still another tool in the tool chest. So
I'd like to address it. I know that when I was counsel for Department of Water and Power, there were apartment buildings that individuals owned and didn't pay the bills, and many of them were actually slumlords, and the buildings would go down, just be deteriorate, and oftentimes the bank would want to have a receiver appointed because the banks didn't want the property back. But on the other hand, you have tenants who are paying they think they're paying the utility bills in their rent, because many of the older buildings in Los Angeles County have 1 meter feeding the whole building. This is a lot of information that you may never ever need again, and I don't even know if it's issued in trivial pursuit. But nevertheless, the point of all of this is that when you have a receiver appointed, you want to have somebody who knows about the business that they are going to be responsible for. Because in many cases, the people who are running the business will sit and tell an uneducated receiver a load of Grimm's fairy tales, and often they can actually have people paying them on the side. You need to have someone who understands how these businesses work. Otherwise, you're basically gonna allow the business to go down the drain and pay the receiver and never get paid. Next slide. Defenses. Okay, so if you go on the Los Angeles County website for forms, you will see two different categories, state forms and LA County forms. There is a form EJ 155 that lists all of the exemptions from enforcements of judgments. This is a very, very important form because it tells you which code section impacts the exemption and what is actually exempted from judgments.
Susan,
For
can
instance,
you tell us that form number again?
sure. Is my face showing to other people?
No, I just have the PowerPoint up right now.
Okay, so let me give you the form because the form number. E like egg, J like judicial, -155.
Okay, thanks.
All right, and it's on the LA County Court website. And when people file claims of exemptions, there's very strict requirements, and Social Security deposits are exempt, but you can garnish Social Security for support if you directly go to the Social Security Administration. But the party who's trying to get the claim of exemption has to file it with the sheriff, and which causes the sheriff to hold any funds that are collected until the court can make a determination on the claim for exemption. But if you miss any deadlines in filing for the claim of exemption, then the sheriff will release the forms. You want to make sure that you record the abstract of support judgment or abstract of judgment with the county recorder as soon as possible. This would impede the ability of a bonding company from issuing an undertaking, since you would have a lien ahead of the bonding company and they wouldn't want to be junior to your abstract. So while the debtor has the burden of proof in these hearings, I really think that it's important that you understand what can be listed for a claim of exemption, just so you're prepared.
By the way, I knew there was one other thing.
And I think there's some more defenses on the next page.
Besides Social Security being, you can go after for support, you can also levy on spousal support.
I think if you go to the next page, they also show some other information on this slide.
Okay, there you go.
Yeah. There's some forms here that are very important that you know about, specifically under F, the FL 678 or the WG 011 wage garnishment form, that you want to serve these orders on the sheriff with specificity so that the sheriff knows what you're actually talking about, because they're familiar with these specific forms. Next page. Ira?
Okay. If somebody files an appeal, there is a provision for a stay, both at the trial court and at the Court of Appeal. However, I have yet to see either of those courts issue a stay without posting an undertaking. The undertaking is, if it's an institutional undertaking, a bond, it's 1.5 times the amount that's involved. And if it's a personal undertaking where you get two people who are stupid enough to sign it, it's twice the amount of the judgment that's involved. And that ensures that if they lose the appeal, then you'll get paid. And if they don't post an undertaking, you're free to execute on anything. It doesn't stop you from doing anything. And a lot of people think because they appeal it, then that's gonna be the end of it. It's not. And it's been taking about 18 to 24 months from the filing of the notice of appeal till the date the Court of Appeal issues its decision. So, you know, and it also, thinking about the appeal, is it gonna be cost effective for somebody to appeal, let's say, an attorney fee order in a family law case of $25,000 when it may cost $25,000 for an appellate attorney. So you have to make a value judgment in that particular case. So I
Do you have
think,
do you have any questions?
yes, we still have a few minutes for questions if anybody has.
Lori, did anyone give you any questions?
Hang on, let me look in the chat box.
Okay.
I have a question, if I may.
Sure.
Going back to the IRAs earlier in the presentation, there was a note there about exemptions, but someone who is not yet eligible for their IRA, I understand that part, but what if someone has got their pension benefits or their retirement benefits connected to the IRA and they're living off of that? Is there an exemption for that as a debtor?
Well, they can apply. That's up to the court, whether the court is going to grant it or not. Remember, you're talking about somebody who's owed money in family law, like for support. So it depends whose ox is gored. Is it the person who's trying to live off the money, or the person who should have gotten the money when it was due? It's up to a judge.
But if the person doesn't file the claim of exemption, then when you file for the payment, the levy on it, unless they file for the exemption, the debtor's going to get paid.
Thank you.
Any other
Okay.
questions?
Yeah, I have a question generally because I did do a little bit of collection work. I'm talking 30 years ago. This seems to apply to general collections as well. Is that right?
Correct.
Yeah.
Yeah.
The only difference is in family law, because you have orders that are made for support, the support goes to the head of the line, so to speak. In fact, it bumps taxes. So if somebody is
Wow.
having taxes garnished and you come along and you have support, the IRS is gonna have to stand behind you until the support is paid. That's the only real difference.
Okay, because it sounds a lot similar to what the collection work I did 30 years ago was very similar issues, like a judgment debtor exam. Very, very.
Lori, I mean, referring back when I was doing at DWP around the same time, it is
Mhm.
very similar. And if you did judgment debtor exams, oftentimes they were useless.
Mhm.
But the one thing I think that does give you a little bit of an upper hand here is that you have information going in because of the documents that were filed with the court. Doesn't mean the person didn't drain the bank account, doesn't mean any of that. But at least you have more information going into it than you have in a typical scenario where you sued on a contract action
Right.
or some other type of lawsuit.
Yeah, and I remember like dealing with pro pers was just like a nightmare.
Well, that hasn't changed. That doesn't change.
Yeah, well, that's true. Okay, any other questions from anyone? Okay, if you're either one of you are available, I'd like to invite you to our Christmas party. It's December 6th. It's for the Pomona Judicial District. It's at noon. It's a great luncheon. We have Santa Claus and Christmas carolers and the whole bit. So it's all the Pomona judges go to that in the judicial district. So it's a lot of fun. We're planning it now. It's going to be at Mountain Meadows Golf Course in Pomona, which is right off the 10 freeway. Also, I wanted to let everybody know before I thank both Mr. Friedman and Judge Lopez-Giss that in October and November we're having 2 AI subjects regarding legal research and law office management. So you'll get notices of those. They go in tandem about how to use AI in your law practice, both for research, law office management, and generally. So I would invite you to our October, November meetings, and then December we'll have the Christmas party, and January, when everybody's up for MCLE compliance in their group, we'll probably do another trifecta for compliance, especially in the there's the new area of civility as an MCL subject. We did that this year. I believe that was the February meeting. So everybody needs to be aware of, there's a new requirement for civility 1 hour in the compliance period. So anybody have any questions before we thank Mr. Friedman and Judge Lopez-Giss?
The only thing I was going to tell you is if anybody has further questions, I'll give you my email address. I don't mind answering, and I've had people do it, and I've never felt that they've taken advantage of me. My email address is IMF, like International Monetary Fund. Just happens to be my initials, at f-law.com.
Thank you, Mr. Friedman.
My
And
pleasure.
Judge Lopez-Giss, you're at ADR, is that correct?
That is correct. That's correct.
Okay, and there I depend on them for getting speakers every once in a while. Lynn Levy, who's a mediator at ADR, I don't know if you know him or not. Great guy, does mostly our ethics subjects for us, for our MCLE. So if you see Lynn Levy, say hi to him for me.
Well,
Okay.
I would certainly be happy to participate in any family law topics you'd be interested in, because I have a place in my heart for how wonderful the Eastern Bar Association was to me. And
Thank you.
I feel that part of the reason I've been able to develop whatever skills I did develop was my time in the East District. So please call on me whenever you think you might, want me to assist.
I will take you up on that, because
Okay.
generally the first of the year we do like family law updates for
Right.
practitioners. So we like each specialty to do an update in the new laws. So that would be great.
Okay, well, then you know where to find me.
I do. All right.
Okay.
Thank you both.
Thank you.
Have a good
Thank you for this
evening.
opportunity. Bye-bye.
Thanks,
Thank you.
everybody. Have a
Bye-bye.
good evening.
Bye.
Good
Bye-bye.
night. Bye.